Thank you. Good morning. We're here in our case 1CA TX16 Arizona Electric Car Cooperative versus the Arizona Department of Revenue. Each side will have 20 minutes to present their argument. Appellant, you may reserve any time that you want for rebuttal, but you'll have to keep track of your own time. We have the clock at the podium for that purpose. We are recording the argument, so it'll be up on our YouTube channel in a couple of days if you want to see how you did. Because we're recording this, we'd appreciate it if you would identify yourself and your client when you begin your argument so that we can keep everything straight. We've read the briefs, we've conference the case, we're familiar with the record, so when you begin your argument, just launch right into what you want us to know. Counsel, you may begin.
Thank you. May it please the Court, I'm Dan Garrett, and I represent AEPCO in this matter, the appellant. There's really three things that I think it's important for you to know in addition to what is in the briefs. The first is, and it's the most important one, and that is that electricity is tangible personal property. That's first and foremost, because if electricity is tangible personal property, then the rest of the issues should fall into place. But I'll address two of those to make sure that we don't get off track as other courts have gotten off track, because I don't believe they've been provided the right information. With respect to electricity being treated as tangible personal property, what's important is that it be the legislature's intent that it be tangible personal property for use tax purposes. Regardless of what experts say or testimony, it's really what the legislative intent is.
Hasn't the concept of electricity as tangible personal property been long established in this state? Why is that an issue here?
I don't know, but the other side is arguing that it isn't. I absolutely believe that it is and shouldn't be a problem, but I just want to point out one more area where it shows that legislative intent, and that is in the imposition language itself. The imposition language for the use tax provides that it's tangible personal property purchased from a retailer or utility business. And in the early 90s, I was general counsel for the Department of Revenue. And at that time, the imposition language was different. It was tangible personal property purchased from a retailer, and there was no utility business. But during the 1990s, there was deregulation. And because of deregulation, there was a separation between the transporters, the pipelines and the transmission, and those who sell it. And because of that, what would happen is you could buy out of state electricity or natural gas and then have it transported in. And if the person you bought it from didn't have nexus, then there wouldn't be tax there. So they wanted to make sure that we had the corresponding use tax. And so the statute was changed to what it is now, which is tangible personal property purchased from a retailer or utility business. But you notice that it doesn't say tangible personal property or electricity. It just says tangible personal property. And if we look at the definitions, utility business it really provides more definitions, but utility business means a person that's engaged in the business of providing electric utility services to retail electric customers or natural gas utility services to retail natural gas customers. And then those terms are defined. A retail natural gas customer is a person who purchases natural gas. And a retail electric customer is a person who purchases electricity. So the state imposes use tax on purchasers of natural gas and electricity under this statute, but there's no reference to electricity separate from the reference of tangible personal property.
And help me. Why is that significant?
That's significant because if you treat electricity as not tangible personal property, then all of the taxes that were collected from utility businesses on sales should be refunded. Because the tax is not on electricity. Purchase of electricity only taxes on purchase of tangible personal property.
But you believe it is tangible personal property?
Absolutely, and I think there's over a...
So the tax is proper then?
Yes, but yes, because it's tangible personal property, the tax is proper. If it wasn't tangible personal property, then it wouldn't be proper.
Right.
So clearly it's tangible personal property, and in the Phoenix there's probably 1 million meters measuring electricity as we speak. So first is tangible personal property electricity is tangible personal property. The thing that I struggled with when I first took this case was the continuity of matter. Usually, in a sale for resale situation, what you have is something that is purchased as a raw material, and then that becomes the finished product through processing or whatever, and the finished product has attributes or has molecules or atoms of the initial item. However, I solved my own dilemma when I realized that electricity doesn't matter. So you can't have a continuity of matter if there's nothing to continuity it into. Electricity is energy, not matter. So if you're going to have if electricity is tangible personal property, and it is, it's physical in nature and all the other things, then the raw material for it should also be energy. And that's exactly how it should be done. And
well, the matter or the fuel is used to generate electricity.
Well, really, what's important is to understand there's a conversion of energy. The energy, coal and natural gas have energy in them.
Yeah.
And that energy is converted into electricity through the generation process.
But the matter that makes up the coal and the natural gas, the physical matter of both those materials is consumed in running the turbine that generates the electricity.
Well, it becomes waste matter.
Okay.
So if you take coal, you're going to have energy, and you're going to have a black rock. Mm-hmm. Afterwards, you're going to have energy and fly ash and bottom ash, which is really the same thing, except one is lighter and goes up the chimney and the other sits at the bottom. So if they wanted to sell for resale under the old way, why couldn't AEPCO say, okay, you want to buy electricity from me? You got to buy the ash too. So that then there's a transfer. I'm taking an orange, I'm going to juice it, and I'm going to make you buy the peel as well as the juice in order for there to be a transfer of matter. And then I've transferred all of the coal to you.
Counsel,
Sure.
I'm a little confused. You're not really arguing it's a sale for resale and therefore not subject to the use tax. You're saying that the coal and natural gas became an ingredient or component part of this electricity. Isn't that what you're saying? Which is a separate
It's
issue.
a two-pronged argument. The first is the sale for resale. We are reselling the energy in the coal. That energy in the coal is being resold in another form. And it's common to have things sold in a different form. You process it and sell it in a different form. And as long as the initial item continues into the latter item, it's a purchase of coal for resale. But really, you don't want to understand it, you don't call it coal. You call it energy. Because that's why they buy it. They're not buying it because they want to use it as landscaping in their field, they're buying it for its energy content. It's priced based on its energy content. You're buying energy.
Is that what the invoices say? Energy? Or is it tons of coal?
The coal is rated based on its energy content, and so you're buying it based on its energy, not its matter. And they would love to be able to buy it without the matter. Then they wouldn't have to dispose of the ash that comes from it. It absolutely is true that they're purchasing energy and then reselling energy in a different form. And therefore, the natural gas and the coal is purchased for resale in another form.
If you're buying trucking transportation of materials and the trucking company buys fuel, I mean, is that an apt analogy, or is that entirely?
I'm not following with it. And natural gas usually comes through pipelines, not trucks to the power plants. It comes in a pipeline, and so the natural gas would come into them, and they would the whole. If you're looking at the reason for the purchase, it's not for the ash. It's not for the whatever pollutant from natural gas there is. They're buying it for the energy. They're buying energy, and they're reselling energy. That's what's really going on. And in the briefs, we explain it all the way down to the conversion of methane and how that works, and that the energy actually in it, inside the bonds of the molecules, that energy goes through and becomes the electricity. And that's the purchase for resale. And really, it would be disingenuous to see the purchase of coal or natural gas as anything other than buying energy. The other thing that bothered me, and is that the definition in the property tax definition of generation of electricity, that the EIA, Energy Information Agency's definitions, and both experts say that generation of electricity means the process of taking a source of energy, not coal, a source of energy, which may be coal or natural gas, and converting the energy into electricity. Our whole modern world that we live in is based on that. Being able to take that energy and transfer it into the other.
Well, the way that you're presenting this is at a very abstract level, that you're using the company is buying energy to convert it to a different form of energy, and that's why it escapes the use tax. But it seems if you look at things at an abstract level, there's a lot that might escape the use tax. I imagine would not be within the intent of the legislature.
Well, I don't believe that a lot would escape taxation, because it's only when you sell energy. If you're selling energy, then the raw material input is energy. If you're baking bread, the energy that's used to do that does not go forward at all.
And why not?
Because the final product is not also energy. It is matter. A pizza is matter. You're buying it for the matter that's there. You're not buying it because of energy was the raw material input.
You're consistently characterizing the coal and natural gas as energy, and I understand that. Would you also concede that they are both of those items are fuel in this process?
Fuel is the same thing. Well, they're not running. They're not using the fuel. They're not using it as fuel to run a machine. They're converting it into energy. It is not consumed, and that's the important part.
But
If it was consumed,
isn't that the only reason to purchase fuel or purchase energy is to make some machine run, or else why buy it?
yes, but it's whether you're consuming the energy or reselling the energy. If you're consuming the energy, I buy gas, I put it in my car, I drive, I'm consuming that energy. I didn't put gas in my car, run a alternator, and sell electricity.
What's your take
I'm consuming it.
What's your take on the department's use tax regulations that seem to, at least by strong analogy, apply here? That the sale of fuel used or consumed in a manufacturing process is taxable.
Yeah, if there is a true manufacturing process where you're using energy to convert matter.
Isn't this manufacturing energy?
If you're manufacturing energy, then that's the object of the transaction, and it's not the energy being used to make it happen. So there's a big difference. And we pay tax. We pay tax on the energy that we consume.
Well,
Just the energy we don't. Excuse me.
Council, aren't you by your construct, aren't you manufacturing a new kind of energy? You're taking the type of energy that is in coal and natural gas, and in your view, you're manufacturing a new type of energy, electricity. So why doesn't that work?
Because I'm not consuming the energy in order to make the product. The product is the energy. If I consume all the if I consume all the energy in the coal in a manufacturing process, there's no energy to be the electricity. The electricity is the energy. And that's where the analogy breaks down the other way. The electricity is the energy that does that. I would like to reserve the balance of my time.
Thank you, Council.
May it please the Court, my name is McKay Mahoney, and I represent the Arizona Department of Revenue in this matter. There are two main issues that appellant has brought forward. Does AEPCO use coal and natural gas in its power plant when it purchases those from out of state? And second, is it entitled to an exemption? Before getting into the actual statutes, I just kind of want to give a brief overview of what is going on in the tax world here. I'm sure you all are familiar with a quote-unquote sales tax that you pay on goods when you buy them at the store. That in Arizona is actually a transaction privilege tax. And a transaction privilege tax is the tax on the privilege of doing business in the state. There are multiple classifications for that, among those retail, amusement, utility, etc. And each one has a specific rules for imposing the tax. Because it's the tax on the privilege of doing business in the state, you have some problems when you get people buying products from outside of the state because the state doesn't have nexus. So what the state does is it imposes a use tax on those products. Here, AEPCO bought coal and natural gas from outside of the state, so Arizona didn't have nexus to impose that TPT tax on the sale of the product. So what we do instead is we impose a use tax on AEPCO's use or consumption of those goods in the state. If AEPCO had purchased those goods, if the coal or natural gas from an in-state seller, notably that in-state seller would have been liable for a TPT on that product, not AEPCO. AEPCO could have passed, or sorry, the coal or natural gas seller could have passed that tax on to AEPCO, which is what you see on your receipts, is the retailer passing on the transaction privilege tax they owe to you. But because that couldn't occur, AEPCO has to pay a use on the consumption. So that gets us to the first issue. Does AEPCO use the coal or natural gas? And I think as the court has suggested in its statements, it agrees with me that, or it would likely agree with me that AEPCO uses this. I don't think there is a more clear definition of use than totally consuming a product in order to generate electricity. That is the statutes require some exercise of control over the good that's brought in. Here, EPCO exercises control by burning it in its power plant and totally destroying the coal and natural gas in order to generate electricity.
Council, if EPCO, and I don't know if this would ever be factually true, but if EPCO bought coal or natural gas from someone in Arizona, would they pay a TPT tax instead of a use tax, or would they pay both taxes?
So what would happen in that circumstance is either the mining company or the retail seller of the coal or natural gas would be liable for that TPT. That person could then pass it on to EPCO as the purchaser, kind of like when you pay a sales tax at the store. The entity doing business can pass that tax on to you. So that TPT would be due on the coal or natural gas on the sale of that product under either the mining or the retail classification. Then there would be a separate second tax on the utility, because the utility is a different classification of TPT, on the electric generation services. So those are the services that are provided to provide electricity to a customer. So you have two separate instances of TPT tax here. What EPCO is trying to do is totally avoid one whole category of that tax by saying, oh, well, we're purchasing energy from out of state and selling energy, and so we should really not pay any tax at all, either on the first, the sale, or the sale of the coal or natural gas, and second on the services of electricity. So they're trying to essentially escape taxation that would occur if that sale were performed in state.
So the payment of under EPCO's theory, the payment of taxes would depend on the location of the seller of the coal or the natural gas?
Essentially, yes. They're saying if we buy it from out of state, there's no TPT/use tax because they're complementary taxes. But if they had purchased that product from within the state, there would definitely have been that tax on the product. So then there would have been two taxes, yes. So assuming that we all agree that EPCO uses this, I think they cited some cases, Motorola and Shamrock, and I think those are easily distinguishable because in Motorola, the federal government took title to these, and in Shamrock, you actually can see the product coming in and the same product going out. I'd like to talk for a second about the exemptions. And I think, it's a very interesting, ephemeral, kind of metaphysical argument that EPCO makes about energy entering into and being constant throughout. But when we interpret exemptions, we need to interpret them narrowly, because what we're trying to do is make sure that all taxpayers are taxed fairly. And when I don't even think we need to get into the statutes of construction, because it's pretty obvious that EPCO is burning all this, so it's not entering into electricity. But if there was any ambiguity in the statute, we would need to narrowly construe it against the taxpayer and in line with legislative intent. And I think here we know that there are two different classifications, one for retail sales, one for electric generation services. So the legislature has demonstrated its intent there that these be taxed separately. I think we've got some exemptions on fuels, where those exemptions would be superfluous if EPCO was, if fuel was just energy, then there would be no need for them to ever exempt a fuel, because it would always just be energy, so that language would be unrequired.
Well, isn't a related point I think you're making is that if the legislature intended to exempt the purchase of fuel in this process, it knows how to do that?
Certainly, Your Honor. And I mean, if you look at the exemptions, there's a long list of them, and they know how to do exemptions. They make them often. I think this is a fairly simple issue. If the court doesn't have any further questions, I'd ask that you affirm the trial court and dismiss appellant's appeal.
Thank you, counsel. Counsel, can you explore the issue of the taxes depending on the location of the seller of the coal or the natural gas?
Sale for resale and incorporation into a manufactured product or processed item, they work under both of them. The purpose, what we're supposed to do is have one tax, not multiple taxes on something. And so here we have a pyramiding of taxes under either methodology. This happens to be use tax, but under sales tax, it's the same thing. There's sale for resale for sales tax, just as there is for use tax, and there's exemptions for incorporated into manufactured or processed product, just like there is both ways. What you want is the last transaction, which usually is the highest value transaction, to be the one where the tax is, and that is. Tax is paid. We're not avoiding all tax. We're trying to avoid the pyramiding of taxes. We're trying to avoid paying tax on energy in the form of coal and natural gas and then paying tax on it again when we sell it as electricity or a final vendor of electricity sells it to a final customer. When we get the electricity.
Counsel, your client has the ability to pass that tax on to its ultimate consumers. Right? So it's not a double taxation here.
In Arizona, it's a transaction privilege tax, and it's not a legal double tax. No, it's an economic double tax. It's being taxed twice economically, not legally. I agree with that. With respect to the exemption in 425159A4 is for tangible personal property which directly enters into and becomes an ingredient or component part of any manufactured, fabricated, or processed article, substance, or commodity for sale in the regular course of business. If we incorporate a part of the coal and natural gas, which is the energy part, if we incorporate that into a finished product electricity, then that is exempt, and the purpose is to avoid pyramiding of taxes because the final product will be taxed at the highest rate to the last person. There's no need to have multiple taxes. There isn't on a bicycle.
Doesn't that presume that the item that's being incorporated into the finished product is something that remains? You can identify it. In other words, can you reverse engineer electricity and end up with coal and natural gas?
Yes.
Really?
The chemical energy, let's see. Both experts, the department's expert as well as our expert, said that all of the energy at the end of the energy conversion process, all of the electrical energy generated is energy that was originally in the coal and natural gas. All of it.
The coal and natural gas that has been completely consumed and eradicated in the process.
Well, not the energy. The energy hasn't. The energy became the electrical energy. What we're saying here is that there's magic, and the magic is that electricity is made of nothing.
Coal and natural gas can be converted into electricity, but I'm confused about how electricity can be converted back into coal and natural gas.
Well, you wouldn't be able to convert it back into coal or natural gas, but some energy conversions can be done. You can convert coal into a artificial natural gas.
Thank you, Counsel. We appreciate your argument. We'll take this matter under advisement and issue a decision in due course. We stand adjourned until the next argument. Thank you.